On Friday, January 28, 2022, folks in Canton, Massachusetts were preparing for an incoming blizzard. But before the storm hit, some of the locals were gathering at two of the downtown bars, C.F. McCarthy's and across the street at the Waterfall Bar and Grill. Boston police officer John O'Keefe, who lived in Canton, met some buddies at C.F. McCarthy's early in the evening. He was then joined by his girlfriend, Karen Reed. After a while, John and Karen went across the street to the waterfall to see some more friends, including John's old neighbors, Chris and Julie Albert. When midnight arrived, the waterfall was closing, so a group of folks from the waterfall headed to Chris's brother's house, Brian Albert. When Karen and John arrived in front of Brian Albert's home, John exited Karen's SUV. At this point, what happens next is in dispute and is the subject of the current trial. Prosecutors say John was murdered by Karen, who backed over him with her SUV, while the defense says John was ambushed inside the Alberts' home and put out on the lawn to die and to frame Karen. Karen is on trial for murder, and now prosecutors are using expert witnesses to put their case together, including an accident reconstructionist. Did he prove what happened, or did he open the door for reasonable doubt? We'll dig into the latest as we continue to investigate the tragic death of Boston police officer John O'Keefe. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. And in any murder trial, you're accusing someone of taking someone else's life. One question most juries want answered is, well, how did it happen? How did it happen? And that's a huge question in this case, because on the one hand, the prosecution is trying to explain their version. On the other hand, the defense saying it never happened. So they're in two completely different places here, okay? Two completely different places. So in trying to figure out how it happened, one way is there any confession? Well, the prosecution's saying, yeah, there is a confession. She said, I hit him, I hit him, I hit him. Okay, so that's how you get to Karen Reed striking John O'Keefe with her car on this alleged confession, which the defense is disputing in the case. But it's evidence. It'll be up to the jury whether or not they accept it. So that's one way you prove how it happened. Well, how about eyewitnesses? What did they see? What did they hear? And the big answer to that is absolutely nothing. Absolutely nothing. And this is a story and a case and a night where there are people coming in and out of that house. Lots of them. It's not like a quiet night. There's a party before everyone gets there. There's a party when people get there. And people are coming and getting picked up and dropped off, etc. Yet no one sees or hears what happens to John O'Keefe. So now what are you left with? You're left with some of the physical evidence. The car, the taillight pieces, the location of the body, and you put those together through expert testimony. And that was Trooper Joe Paul. So the question is, did he convince this jury how it happened? That's his job. That's his job. This is kind of like what you saw in the Alec Murdaugh case when Dr. Ken Kinsey put the pieces together for the jury and told them what happened. Now, one of the problems for the prosecution is that Joe Paul is not as experienced or comfortable on a witness stand testifying in a murder trial as Ken Kinsey is. And this is a case where the other side is going to have their own experts. So it becomes a battle of the experts. So when you have a battle of the experts, there are a lot of factors that go into analyzing which expert the jury is going to believe or which expert the jury finds more credible. Because it's going to be two different stories that they're going to hear from two qualified experts, at least two qualified experts. So how you testify and the word choice and the back and forth and the demeanor, it all has a huge impact. Getting back to Murdaugh again, Kenny Kinsey is extremely comfortable. He was like teaching the jury. He was walking us all through what happened that night and taking the evidence from the scene and telling a story with it. Like the crime scene was speaking to him. Well, Joe Paul was saying the crime scene was speaking to him, but I don't know what it was speaking, because it was just a different experience today. There were times where I felt uncomfortable watching. It's not because I'm cheering for either side. It's just an uncomfortable to watch because you can tell that you have a very experienced attorney questioning an expert who I don't know if he's ever been in a position quite like this before. Most accidents are probably a little more straightforward, right? Two cars crash, skid marks, and you put the things together and you can tell the story. But here you're telling a story that the other side said never even happened. So there's a lot more pressure on you, number one, a little less evidence, no witnesses, so it's a much more difficult task. And the question is, did he convince this jury? I'm not sure. I'm not sure. If I was the prosecution, I would not be super comfortable with all this. Now, let's get to the biggest piece of evidence for the defense, and that's this Google search at 227 by Jennifer McCabe. This is the smoking Google that they say absolutely proves that there's no way Karen Read could have done it. So there was expert testimony today from a man who works for the company where they extract the information from the phone, Cellebrite. So Ian Whiffen testified, and the question from his testimony is, did he shut down the defense? Because much differently than Joe Paul, you could tell he was very comfortable on the witness stand, knows his stuff inside out, and he works for the company. So his explanation was pretty compelling, pretty compelling. Let me tell you, the defense has their work cut out for them if they want to neutralize this expert. Anyhow, there was someone else who was in the middle of all this today. Court TV crime and justice correspondent Matt Johnson joining us live from outside the courthouse in Dedham, Massachusetts. Matt, great to see you tonight. So you're our expert tonight, okay? So they call their experts, we call our expert, that's you. Tell us about Trooper Joe Paul's testimony today.
Well, you know, you're right, Vinny. We're at week 8 in all of this, and I really feel like this is the first time that this jury has heard any sort of explanation into the Commonwealth's theory as to how this murder took place in their eyes. Why Karen Read is charged in the first place. Are they finally connecting the dots? Well, here is what Trooper Paul said on the stand.
So the vehicle was traveling in reverse.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
What, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
So you saw right there when he was giving testimony, we just played that video when he's holding his arm up. This jury loves that sort of thing. They love to see evidence and they want explanation. So today on cross, he was also asked, how do you think those injuries took place on John O'Keefe's arm, those scrapes, and how does that relate to your theory, Trooper Paul, with this crash? Take a listen.
Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered?
How does the taillight, what do you mean? So the taillight in this case was shattered when it was struck John O'Keefe's arm. Based on what I saw for his injuries was from the upper part of his arm down.
He gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that we see, those lacerations, I'm sorry, those abrasions that we see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise.
The defense seemed pretty happy with that cross-examination if you're looking over at Karen Read and that defense table. Again, this is just the beginning of what is going to be a battle of the experts. The defense says that they have been dealing with this issue and the house long to die in cold for 2 years, and they're ready to put their own experts on.
And, you know, what's interesting about Joe Paul's testimony, and one thing that really struck me was he had difficulty telling the story when he was trying to wrap it up at the end, you know, like his conclusion, and he was reading his report, which you're not allowed to do, and then he was trying to do it without reading his report, and he kept peeking down at his report. He wasn't making that same connection that I've seen other experts do. It doesn't mean the case is over. It just means that in a battle of the experts, your expert did not take control of the courtroom the way some experts do, because they're very experienced and very good and comfortable. He just didn't seem comfortable in there today. Okay, so let's get to the other expert, the Cellebrite expert. And to me, this was a different story, a different situation. What did you see in here?
He seemed very confident. He's a decoding manager. He's with Cellebrite company that these police agencies use. He's former law enforcement himself up in Canada when he migrated from the UK. Ian Whiffen was on the stand, and he was talking about Jen McCabe's now infamous search that really started all of this for the defense. House long to die in the cold. He said that it didn't happen at 2:27 in the morning. He said that it happened after 6 a.m., which would be after O'Keefe's body was found on the lawn of 34 Fairview. And he said that it was done on an open search, you know, through Google and through Safari. So take a listen to his testimony.
The original question is just basically, how can we explain this 2:27 timestamp? I spoke to my colleague and requested if he could contact the investigators and any information that they could share about where this particular timestamp was found. There's plenty of other evidence on that extraction that shows what activity was occurring at 2:27, 40 seconds. And there's plenty of evidence later on in the day that shows that that particular search was conducted at 6:23, I believe 51 seconds, and then a similar search at 6:24 and 18 seconds, I believe.
Are you preparing to challenge the timestamp on House Long to Die in the cold?
Am I preparing to challenge it?
Yeah.
I've been challenging it for 2.5 years.
Sorry, when you bring it...
They're challenging it. I know what the time was. It was 2:27 a.m. They're challenging it, not doing a very good job of it, by the way.
There was also something really interesting with his testimony, this expert from Cellebrite that was on the stand, because he said that even though in his determination of an analysis of the cell phone records that he believes Jen McCabe did not delete any of the searches, he couldn't duplicate that, and he called it spontaneous deletion. And that's also part of the reason why you got that response, that very fired response from defense attorney Alan Jackson at the end of the court day out in front.
Yeah, that was a piece of it that was not great for him. But it seemed from the cross-examination today that they're going to allege that this expert from Cellebrite was given manipulated data as part of what he was to analyze. So it'll be interesting to see how that sort of develops, if they have evidence of manipulated data, because that's what I took away from the cross-examination. Okay, the end of the day, so we go through these two experts, and then we finish up with more text messages today.
Right, so in very important text messages, and there was another trooper on the stand. So this is Trooper Guarino, who is on the stand talking about the relationship. We're at the motive area of this trial for the Commonwealth. And remember, they're alleging that there's a breakdown in the relationship between Karen Reed and John O'Keefe right before, and they're also alleging that they got into a fight before she backed into him. That's what they're saying. Well, today he was reading text messages of the couple hours before John O'Keefe's death. Take a listen.
So you're not into this anymore? And then John says, not into fighting all the time, correct. That's at 2:34 p.m.
If I could turn your attention to the top of 12.
Yes, 2:34, Ms. Reed says, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world. And then at 2:34, she says, then stop starting with me.
How does Mr. O'Keefe respond to that?
At 2:34, he writes back, I'm not answering, stop calling. You're starting a rager with me out of nowhere, and then you tell me you're sick of fighting with me. At 2:35. She writes at 2:38, I'm going to grab a drink in a bit.
So then there's a moment, aside from the text messages, that Trooper Guarino is reading on the stand. And this is all over social media right now, and anyone that's paying close attention to this trial, because on a hot mic, when he's on the stand at around the time he's going to start reading those text messages, it appears that he doesn't want to do that because he says, "Kill me." Take a listen.
Material that you reviewed from the defendant's phone, is that consistent with what you observed in Mr. O'Keefe's phone?
Yes, it is. Kill me.
Did you hear it? He's whispering on that hot mic, "Kill me." Well, you know what? That room, that courtroom behind me is very tight. It is close quarters, so who knows who heard that. But remember, when we're talking about the couple's relationship, John O'Keefe and Karen Reed, we have already heard about that fight in Aruba. We've heard that from several witnesses, and we've yet to hear about any voicemails that were left. But here is what Alan Jackson said outside the courthouse.
They just spent the last half a day establishing that John and Karen had the most absolutely normal relationship on the planet. Show me someone who hasn't had normal ups and downs and fights and makeups and breakups and get back togethers and, you know, all the normal stuff. Certainly nothing that establishes or even suggests a murderous intent, which is what they have to show.
I know you can't say much, Karen, but is there anything that you can say about your relationship?
It was normal.
And you loved him, I'm sure.
I didn't. We were dating. We were dating.
I did love him, and we were dating. That's what her answer was to that. Again, still no decision whether or not she's going to take the stand. But if she does, she's going to be asked quite a bit about her relationship right before his death.
Oh, absolutely. But I'm not banking on her testifying. We shall see, though. Matt Johnson, Dedham, Massachusetts tonight. Thank you so much, Matt. I want to bring in a special guest joining me, attorney Richard Grundy, former prosecutor, now no longer prosecuting, but has great insight into what happens inside of a courtroom, especially with jurors from this jurisdiction. What do you think of motive? I just want to talk about motive right now, because I know you're going to be with us for the hour. This motive of they're fighting all the time. What I'm hearing in these text messages is that she keeps calling him, keeps texting him, you know, that day before. Does that add up here? Is the jury going to believe that's a reason that she would purposely throw the car in reverse and take the life of a man who was raising 2 children who were orphaned?
So, Vinny, when you and I started this conversation, one of the first things we agreed upon is that the case was overcharged, which at that overcharge is what brings motive into it and some level of intent. So I think they've got to go with what they have, because they put themselves in an awkward situation. They had a tough enough case on their hands without doing that. So this is what they've got, and this is what they've got to go with. Does it make sense? It makes sense if you put it together with the fact that she's drunk as a skunk. But that takes away from the intent. So in my opinion, you should have never gone with the second degree. And yeah, they're fighting. She's angry, and her cognitive abilities are greatly impaired while she's behind the wheel of a car. She has some understanding of what she's doing, but it's not something she would have done if she had been in a right frame of mind as far as her sobriety was concerned.
And I just want to get a sneak peek of what happens at the end of this case. Does the prosecution argue for all or nothing? Does the prosecution say, well, if you don't think it was murder, you can find her guilty of something else?
So I think the prosecution, if they've got any real handle on how this has gone in for them, absolutely asks for lesser included. And I think the question then becomes, if I'm on the defense side, do I say, I don't want my jury to be instructed on any lesser included? These are the charges, and we ask the court go forward strictly on those. I think the judge will still allow lesser included instructions, but if I were on the defense side, I'd think seriously about asking, nope, leave it as they chose it to be.
Yeah, again, you know, from the beginning, the motive and the reason and the murder, It seems like it is a lot to prove under these circumstances. All right, Rick Grundy's going to stay with us for the hour. When we come back, we're going to break down this expert testimony with our insiders. Plus, coming up next hour. A major development in the investigation into the murder of Rachel Morin, who was found killed in Bel Air, Maryland last August. Investigators have finally tracked down a suspect, and tonight we'll show you how they did it and get reaction from Rachel's family.
Wednesday.
The ultimate betrayals.
Back-to-back episodes of Accomplice to Murder.
Spell was broken when the handcuffs went click.
Friends and family turning on each other.
What he was willing to do for $1 million.
But just who is the puppet?
She was a master manipulator.
And who's pulling the strings?
An Accomplice to Murder marathon. Starting Wednesday, noon, 11 Central.
Only on Court TV.
So the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? It just struck the arm like a hinge? Was it in front of him? You did the reconstruction?
It looked
sure is exactly how his body was positioned when he was struck by that.
So it looks like his arm was more kind of like this, if I can try to get that.
Crucial moment, crucial testimony. This is the expert for the Commonwealth of Massachusetts trying to convince the jury beyond a reasonable doubt how John O'Keefe was murdered by Karen Reed. So he works for the state police. He's got the training to be a guy who can give expert testimony about reconstructing traffic scenes. Now, this one's a little bit different. This accident, or it's not really an accident, right? It's a on purpose if it's murder. But it's not like on a highway where there are two cars and you see where they end up. Aren't skid marks. There's things like this that aren't present at this scene that I'm sure he's used to dealing with. Much different. Let's watch.
So he gets hit on the upper biceps, shoulder area, and down to the forearms, right?
Yes.
By an unbroken taillight, right?
Yes.
In other words, it's nice and smooth. Nothing, no shards of plastic or anything broken at the time that it made contact with his arm, right?
Correct.
Okay, so how did his arm get all cut up?
Because when his arm struck the taillight then cracked, and as the car driving past him, the taillight could scratch it.
Got it. So he gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that we see, those lacerations, those abrasions that we see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether or not he went counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
hinge.
hinge.
Shoulder?
Okay.
Okay. So, your arm got hit. Didn't his arm just swing?
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got the upper, pointing to his upper biceps. Mm-hmm. Right? There's no injuries on his shoulder. Not a single one. Not even a bruise. Right?
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
so.
You're the one that talked about his injuries on his arm.
Yes.
That's limited to about mid-biceps, to about mid-forearm, correct?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight, on the arm, stayed with the vehicle long enough for the taillight to explode, basically to shatter. Then these striations get on his arm, abrasions. Does a pirouette, a spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah, it happened probably a little faster than that, though.
Does this make sense? Let's bring in our guests, our insiders. Joining us, Karen Reed supporter, creator of Justice for Officer John O'Keefe and the Karen Reed Facebook page, Nick Rocco. Also still with us, attorney Rick Grundy, and the YouTuber behind Yellow Cottage Tales, Kevin Lenahan. Kevin, I want to begin with you on this one. Does this make sense to you on what happened?
Yeah, I mean, I would say I'll just make 2 points. One is that, yes, this is almost, to me, malpractice on the part of the prosecution. The most important part of the case is to present their accident reconstruction theory to the jury, and they didn't do a very good job of it. But two, once all the data is pulled together here, it's bulletproof, because they're going to show that the key cycle, I don't know why this trooper wasn't allowed to do this, but it correlates with the data on John's phone perfectly. And it shows that when she did the 3-point turn, that's because she missed the turn onto that street. And then 8 minutes later, that's when his health app shows that the phone stopped moving. And that correlates perfectly with the events that are on the key cycle data.
Okay, Nick Rocco, what doesn't make sense to you here? Because I'm sure some of this doesn't make sense to you.
A lot of this really personally does not make sense, just due to the fact of, if John's arm was struck by this vehicle, only his arm, he would have a broken bone, a fracture, he would have a bruise on his arm. And one of the most important things is the DNA that was found on that taillight was touch DNA. It was not a blood sample. So if what this reconstructionist is saying, that the arm gets struck by this vehicle, which explodes the taillight into 45 pieces, and cut his arm, there would be blood all over the taillight pieces, but they did not find that on there. And the fact of Friday, he stated that John could have got hit by the car, fell down, hit his head on the curb. And today we're learning that his arm gets hit by the vehicle, he spins around, whether it was airborne or it was airborne and rolled to his resting place. How did he get 30 feet? How did the glass end up next to him? How did that phone end up underneath him if all of this stuff was caused by being hit by a vehicle? There's no way he went from the fire hydrant to the flagpole if only his arm was struck.
Rick,
that just doesn't.
I'm looking at the dynamic in the courtroom, and I've watched trials where an expert takes over. You know, it's almost like a teaching moment. They're bringing the jury along. The jury is the students, and they're listening wide open. They want to learn. And, you know, the expert guides them through everything. I saw it in the Alec Murdaugh case. I've seen it in other ones as well. The Derek Chauvin case, same exact thing happened. That didn't happen in this courtroom. It really didn't even happen on direct, let alone cross. What's your take on how this evidence came in for the prosecution and how it landed today?
I think there's an overall theme here. I think the prosecution has done a poor job on all of their presentation. And evidence is, this prosecutor seems to just put the words out there or put the piece of evidence out there and hope that it speaks for itself. You know, there's an art to this, and I don't see the art being performed here. If we got back in our time machine and went back 23 years ago, Vinny, you might remember a guy I had in our case, Kenny Martin, who was a crime scene analyst, who was that person who not only could do the work, had the brain and the eye for the forensics, but could communicate it to a jury in a convincing manner. This guy just didn't have it. He put the information out there, but now you're leaving it to the jury to do what they will with it. And I'll tell you, the bottom line here, and you hear it from the two gentlemen, you've got to be careful, Vinny, because my 23-year-old daughter, who's your biggest fan, asked me if I was going to be on the Rocco Linehan show today. But you hear it here, and one of the few things in my trial advocacy class that I actually can take ownership to is that I tell them you have two hurdles to get over. The first hurdle is to make that jury want to decide in your favor. The second hurdle is to give them the evidence to do that. The first hurdle is the most difficult one to get over, because once you get them on your side, so to speak, they're going to hear things differently. And in a situation like this with that expert, those jurors have a leaning already. So that expert came across in a way that you're going to hear that evidence the way you've already kind of leaned in the case. He's not going to pull you back in if you're on the other side. So, like I say, the information came out, but did it land? Not very well.
Well, the question is it the Lenahan and Rocco show or the Rocco and Lenahan show? I'll let them fight about that during the commercial. But Kevin, seriously, how do you believe this tail light was shattered? The most important piece of evidence we've been talking about so much, all these pieces, either they're planted there or they're evidence of this accident, but how do you think that the tail light itself shatters?
Yeah, I've spent much of the last year trying to figure it out and looking forward to what the state's theory would be, and find myself a little bit not overly impressed with it. We're going to hear more from the medical examiner, though. And my understanding, so Tully had kind of hinted at there is a pattern of wounds on part of the arm that matches up precisely with a taillight piece. So hopefully that's something they'll be able to present. But it looks like the glass was in the hand, and that struck the front where that dent is, and that the taillight broke on the elbow. Now, whether that would, like Nick was saying, should that cause a blood and a gash? Should that break the arm? Should there be bruising? Those are stuff that we have to hear from the medical examiner.
And as we sit here tonight, Nick, and the defense is going to have their own expert. We already know, because this is the way trials work. The defense expert is not going to agree. He's going to say something completely different. And you know, who this expert is and how they testify could have a lot to do with this. Do you believe that the taillight was broken in the driveway at all when she backed into John O'Keefe's car? And if so, were there any taillight pieces that were left there?
Are you asking me?
Yeah.
Yeah, of course I believe that her taillight was broken in the driveway. Whether
so where are the taillight pieces there? That's the part I'm wondering. Like, where did they fall? What happened to the taillight pieces?
Well, really two things could have happened. So the clear piece that she broke in the driveway was never found by the Massachusetts State Police. So it's either a clear piece had fallen in the snow in her tire track, exactly where she made point of contact with John's vehicle, or it went inside the housing, and you know, as she drove off, whatever happens, it's not in there. But I truly believe that when she backed into John's driveway, that clear piece broke, had fallen on the ground. You're not going to see a piece of clear taillight in the snow if the Canton police couldn't even find 3-4 big red pieces in the snow. How are they going to find the clear piece?
All right, our inside. Go ahead.
The reason why none of this makes sense is because she actually dropped them off at the mailbox and not the flagpole. So they're trying to recreate this story. That's why none of this is adding up.
All right, our insiders are staying with us. When we come back, we're going to talk about the 227 search. Was it a 227 search? That's next.
You see this first search that says hostile armed to dying cold?
I do.
What's that time?
You've got the, it's right over at 2:27
AM or PM?
a.m.
Ms. McCabe, you made that search at 2:27 a.m. because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not.
Jennifer McCabe has been in the crosshairs of the defense for a long time now because of this alleged search at 2:27. If she searched at 2:27, Karen Reed has nothing to do with the death of John O'Keefe. However, she has denied it. Here she is testifying about what she was actually searching after she got home from the Waterfall Bar and Grill.
I was researching, my husband and I did briefly talk. My daughter had gotten an offer to play on a club
Just tell us what you were doing, please.
Sure. I was researching a basketball team, and I believe I also texted my sisters, and I texted in a group chat with my husband and another individual.
So that leaves us to the question, when exactly did she make this search, this hose long or hos long to die in cold? Take a listen.
She grabbed my hands and she said, Google hypothermia, Google how long it takes to die in the cold. And so I had my phone out and it was cold and my hands were frozen and I have MS, and I took my phone out while she was screaming and shaking my arm, and I attempted to Google how long does it take to die in the cold.
So she's saying it's because she is asked to search that by Karen Reed the morning that they find John O'Keefe's body, the following day. So back to the experts now. It's a battle of the experts because there's the extraction of the data from the phone. What does it show? So the prosecution brought to the stand someone who works for the company, whose software does this extraction. He works for the company. Ian Whiffen is his name. Take a listen.
In conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone basketball and Hockomock Sports websites. The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hos Long to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages. Safari was closed prior to the Hos Long to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record where Hos Long to Die in the Cold was shown on screen, even though the page never successfully loaded.
Okay, so Nick, you know, this was like the big piece of evidence going into this trial and going into the entire understanding of what the defense was going to do here, like the foundation of it. And it seems from the cross-examination I watched today that the defense attack on this witness really will be that the information he was given was somehow tampered with before he did his analysis. Am I reading that right? Is there something else going on here?
No, I believe they're saying that because Jennifer McCabe's husband, Matt, owns an IT company, and, you know, IT guys would know how to do those things. So when Ian Whiffen had said, you know, it would take experience for somebody to be able to alter those things, I think that experience would lie in the hands of Matt McCabe and, you know, whoever else may work for his company.
Kevin, this, I thought going into this trial was going to be the strongest piece of evidence. From where I'm sitting, it's not because of an expert like this. I know you've had mixed feelings on this evidence and your opinion changed somewhat. What did you think about today, and what do you think it means?
Well, I think the witness was unimpeachable, right? And so now we have two outstanding experts that have debunked it, and it's debunked by logic itself. Karen was asking the paramedic on the ambulance to look for the same thing. It doesn't really make sense that Jen McCabe was at home researching her daughter's basketball league, and at the same time, oh yeah, what are they going to do when they murder my friend by putting him out on the lawn? So I think this actually not only damages the case, it damages it from another perspective too. There's some legitimate questions, for instance, today about the accident reconstruction theory. But I believe this jury no longer it considers this defense team credible at all because of things like this. So I think it's been useful to stir up a mob, but it's been very damaging to the jury, I think.
I think you just called Nick a mob. Rick, let me ask you this: how does a jury in this jurisdiction, you know these folks really well, Will they hold it against the defense if they believe that this Google search was never done, Jennifer McCabe is not part of any conspiracy, despite the fact of all the other problems that we've seen with the case, that this particular piece of evidence may not be panning out the way that it was promised?
Goes back to also, Vinny, to our first discussion where I said, Dave Yannetti gave a very powerful, strong opening statement. I thought it was great. But I did say, he bit off more than he had to, and that could come back to him when he said, we're going to show that there was a purposeful, intentional framing of the defendant that involved all these people. So I think when you put yourself out there with that kind of certainty, and if it falls flat, you lose some level of credibility. However, I think, again, the nature of this evidence, where it's coming in at the trial, people are going to hear it how they want to hear it at this point in time, including jurors. I think, quite frankly, if the defense is relegated to saying that it was manipulated, that's to the prosecution's favor. They had a good witness on this. The person asking the question wasn't quite as good because he let him kind of rush through it. He was making 3 good points in one sentence. You want him to say it 3 different times. That the rule of 3 is don't clump them in 3. It's to say it 3 different times. But I think again, it's how they're going to work with it from here. It's how the prosecution is going to work with it from here. And that's, I think, where they've fallen short so far.
Nick, let me ask you, from your perspective, being part of the movement here, this piece of evidence, where does it rank? Is it still, from your perspective, the biggest piece of evidence, the smoking gun and all this, or is something else bigger? Where would you sort of rank it at this point?
I mean, whether the Google search, so today what we saw in court is that the prosecution is basically playing the lawyers for Jen McCabe in this situation, proving that she didn't Google this instead of spending their time on prosecuting Karen Reed. If they had all the evidence they needed, they wouldn't even have to debunk the Google search. They wouldn't have to debunk any of the Alberts doing anything in the home. The reason why they're doing that is they're trying to get ahead of the defense's case, right? But if they had all the evidence they needed, it shouldn't matter what the defense is going to claim. If you have the proof is in the pudding, right?
Proof out there.
So if they have it, that's it.
We are out of time for tonight. That's the only reason I ever cut off Nick Rocco, is when I'm out of time. Nick Rocco, Rick Grundy, Kevin Lenahan, thank you all so much. We'll see you again tomorrow.